Hello, everyone. Welcome to Socialist Action webcasts. This is webcast number 4 in the new 2024 series. My name is Elizabeth Bice, and I'm the Federal Treasurer of Socialist Action, a member of the NDP Socialist Caucus Steering Committee, a past secretary of the Toronto, New York Region Labour Council. We acknowledge that this event is taking place on Indigenous lands across Turtle Island, known as North America. That includes the unceded territories of the Mississauga of the New Windot and Haudenosaunee people in a place called Toronto. Today, I'm speaking to you from Jamaica, where the indigenous Taino and Arawak-speaking people began arriving 4,000 years ago. They were wiped out by the European colonial powers. We joined in the fight for justice, recognizing that there can be no real reconciliation without restitution. That entails seizing the assets of the big resource corporations and returning them to the commons. Tonight's topic is, what is Online Arms Act and what is its significance for working people, for socialists, and for activists critical of the Canadian state? In tonight's essay webcast, we will take a deep dive into the deep state by examining the recently passed federal bill with Toronto-based leading Socialist Action comrade John Wilson and Aislin Jackson, author of The Arrest Handbook, and the British Columbia, and she's a British Columbia civil liberties lawyer. So we are glad you're joining us to hear their presentation and participate in the Q&A period at the link above. We are living in truly unprecedented times. Surveillance of the population by corporations and the state is more widespread than ever. Artificial intelligence threatens more intrusion into our lives. Now, the federal government seeks to limit freedom of speech on social media and the likes. Our speakers will present their views for about 20 minutes each, and then answer questions from the audience. So let's welcome our first speaker. John Wilson is a founder of the modern gay liberation movement in Canada, leading the first gay rights march on Parliament, which occurred in 1972. Based in Toronto, John is a member of Queer Ontario, writes for the Red Review, and serves on the Socialist Action Central Committee. So welcome, Comrade Wilson.
Thank you. Okay, I'm going to start off by reading an article that I wrote for Red Review. So apologies to anybody that read it. So you will be hearing it twice. But anyway, on February 26th, the federal government tabled Bill C-63, also known as the Online Harms Act, in Parliament. At 100 pages, this verbose, imprecise proposed legislation has so far not resulted in much public discussion, but it should. All of us who support freedom of speech and other democratic rights should be urgently concerned about the dangerous threats this bill contains. Coming from the same government that imposed the Emergencies Act to deal with the illegal occupation of downtown Ottawa by the so-called Freedom Convoy. This was to paper over the almost total inaction of state agencies, definitely including the Ottawa Police, the federal government, and the Ontario government on this issue. Several critics of C-63 have pointed out that the offenses cited in the bill are already dealt with by existing law. It's not that they are legal now. If existing laws are not adequate, they can be changed. Mostly, though, these existing laws historically have rarely, if ever, been enforced. So why the big emergency? Another con job. Probably the most dangerous item in the bill is the creation of a new regulator, the Digital Safety Commission. Here's what the executive director of the Canadian Civil Liberties Association has to say about it. Quote, One troubling aspect of Bill C-63 is the vast authority bestowed on a newly established body comprised of government appointees to interpret the law, make up new rules, enforce them, and then serve as judge, jury, and executioner. Granting such sweeping powers to the one body undermines the fundamental principle of democratic accountability. Furthermore, the bill's provisions, which include sweeping new search powers with no warrant requirement, pose a significant threat to privacy rights. The bill provides for unacceptable intrusions into individuals' digital lives, unquote. Margaret Atwood, arguably Canada's most prominent author, calls the bill Orwellian. In 1984, Orwell's best-known book, A Future Totalitarian State, which uses surveillance on citizens in their own homes, the Ministry of Truth erases facts and history in order to bolster the regime of Big Brother. So far, we've heard little on this from the NDP and the labor movement, both of which should have denounced it when it was first tabled. Two main reasons: the complaint process and the prevention of future crime. Anyone, even non-citizens and non-residents, can make a complaint to the Canadian Human Rights Commission. It is not a judicial body, so the evidence required to make a decision will be lower than in a court. The same is true of the Digital Safety Commission. The evidence is not, quote, beyond a reasonable doubt, unquote, but on reasonable grounds, whatever that means. If you are an accused, you do not have the same rights you have in a court. Moreover, hearings can be held in secret, and you don't have the right to face your accuser, even know who the accuser is. Orwellian indeed. Complainants have the right to be compensated for costs. The accused does not. As well, those convicted may have to pay the complainant $20,000. Cost of the accused may run into the thousands of dollars for legal representation, not eligible for compensation, even if the complaint is dismissed. So, even if the accused is not found guilty, the process is the punishment. Many bill critics have pointed out that this is an incentive, money and revenge, to make a complaint, and that there will be a tsunami of complaints to an agency that already has a huge backlog. And now to the prevention of future crime. If a complainant, quote, fears on reasonable grounds, unquote, that another person will commit a hate crime, a judge may order their imprisonment or subject them to house arrest and require that they wear an electronic monitoring bracelet. This is obscene, unbelievable. Even with all the Harperites on the Supreme Court, it is hard to see it not scrapping this provision. Harmful content is defined as content that promotes violence, that incites violent extremism or terrorism, that sexually victimizes a child, is used to bully a child, that induces a child to harm themselves, or intimate content communicated without consent. Most people would likely agree with that. But here is more that the executive director of CCLA says. Bill C-63 risks censoring a range of expression from journalistic reporting to healthy conversations among youth under 18 about their own sexuality and relationships. The broad criminal prohibitions in the bill risk stifling public discourse and criminalizing political activism, unquote. This should be sufficient to show that this legislation is a can of worms. We should oppose it and demand the NDP, the labor movement, and community activist groups also oppose it. So let's get to work on that. Now, when I mentioned a can of worms, I wasn't meaning to be insulting to worms. It's sort of like if you call cops pigs, I think that's a monumental insult to pigs, who are better behaved and more intelligent, generally speaking. Anyway, I think the danger of hate legislation is it's one thing to say that it's to make illegal making threats against people or against groups or making threats in general, but simply it's going to be up to the government to decide what hate is and is not. And if you read the National Post, which I call the National Pest, but anyway, they have really gone to the hard right. So if that whole media group which the Post belongs to, I mean, they write apologetic articles about Donald Trump. They pander to anti-vaxxers and people who hate trans people, and they're completely dishonest. I mean, the media as a whole, of course, can't generally be trusted, but these people can't be trusted at all. They never reduce any evidence for anything they say. They, for example, refer to pro-Palestinian marches in Ontario as hate marches, which of course they're not. And they never reduce any evidence to make this. It's sort of saying, well, if somebody is opposed to the existence of the state of Israel, that's anti-Semitic. It's not. It's not. Israel does not speak for all Jews. Certainly the majority of Jews support the state of Israel at present, but the number is going down, obviously, and with the numbers of Jewish people in North America in particular coming out to support the Palestinian cause. So, it's something that we should watch because what could happen, of course, is that they make it an offense to incite hatred, quote unquote, against the rich, for example, and don't put it past them to do that. Particularly if Polyev becomes prime minister. But it could happen with liberals as well. And you get a whole sort of hysteria going about hate speech, and you can call anything hate speech, and that can't be, you can't allow that to happen. So I think, generally speaking, socialists should not support hate crime laws of any kind because they do not solve the problem. They need to be confronted in society, and the racists need to be confronted in person. And it's up to the community to do that, not the government. Anyway, that's about it for me, I think, at this point.
Okay, thank you very much, John. Okay, so now let's hear from our second speaker. Aislin Jackson is a member of the BC Civil Liberties Association and is a lawyer. They wrote the book, The Arrest Handbook. Aislin attended law school at the University of Toronto, where she was co-editor-in-chief of the Indigenous Law Journal. Aislin started their legal career in the Treaty 7 area, representing First Nations in a variety of areas of law, including historical claims and child protection matters. They later practiced family and estate law in the Lower Mainland, serving legal aid clinics and 2 LGBT plus families. Aislin joined the BC Civil Liberties Association as staff policy counsel in July of 23. Welcome, Aislin.
Thank you. And I'm afraid I must be a pedantic lawyer and make a small correction. I can't take credit for the arrest handbook. That was a team effort. It's a publication that we've been putting out for decades, and the latest version came out in September of 2023. So a lot of the work on that predated me coming to the organization. So by the way, that resource is available for free online as a PDF, and you can write into us to get sent copies of it. We put it out in 5 languages, and we also have pocket-sized versions, as well as a more recent version we put out that is aimed at being a resource for students who are dealing with police in their schools. So that's just a little bit of clarification, and I suppose a small plug, which I hope you will forgive me for. Yeah, so I want to discuss the Online Harms Act a bit. It has passed first reading. It's still awaiting second reading, and we're not even at the point where we're talking about the committee process, but we still have quite a bit of time to influence the way that this legislation comes out. And we're referring to it as the Online Harms Act, but really that's part 1 of the bill. And in some ways, it's the least objectionable part. It establishes the new Digital Safety Commission, which, as we've heard from my colleague earlier, there are quite a bit of concerns about the scope of the powers, as well as the resourcing and the procedures that they use, such as, there aren't going to be subject to the formal rules of evidence, which are in place to make sure that the evidence they're relying on is actually reliable. For the most part, part 1, which is the Online Harms Act, is targeting the operators of what are called regulated services. We don't know exactly what online services are going to fall into that, because that's going to come in the regulations to the legislation, which don't get made until after the legislation is passed. But in general, we're looking at large social media platforms, or social media platforms that have, because of their nature, are particularly likely to have content of concern on them. There are duties that these operators are going to have to prevent and take down content that's defined as harmful content. And in the Act, there are 7 kinds of harmful content. One is intimate content communicated without consent, which is often referred to as revenge porn. Another is content that sexually victimizes a child or re-victimizes a survivor. And there's content that induces a child to harm themselves, content that is used to bully a child, content that foments hatred, content that incites violence, or content that incites violent extremism or terrorism. The definitions for these types of hateful content, or not hateful, rather harmful content, are one of the main points of concern that are emerging around the Online Harms Act in particular. For example, the use of terrorism and the way that that's defined could have an effect on a variety of types of political action, because it and the inciting violence part, they include property damage as a form of violence, which can be quite broad. We've seen police characterize things like postering or putting washable paint on something as forms of property damage. So that could potentially bring them inside this inciting violence, which is a grave concern, especially because the characterization of it as terrorism rests on there being an intention of intimidating or denouncing the public or any section of the public, or compelling a person, government, or domestic or international organization to do or not do anything. So it's very broad and would on its face capture quite a bit of political activity. We're also concerned with content that incites violence explicitly includes content that could cause a person to commit an act that could cause, quote, serious interference with or serious disruption of an essential service, facility, or system. And this raises concerns about the type of protest and land defense activity that we've seen with railway blockades, for example, or conceivably a pipeline could be designated as an essential service, facility, or system. So that has the capacity to bring all kinds of advocacy relating to those kind of political activities under the ambit of this and imposing obligations on operators of these regulated services to tamp down on that. There's also a concern that there's no duty on these operators to safeguard free expression. Although there is a carve out that says that they don't have to necessarily take things down in free expression, but there isn't anything that says that they have to respect it. And in my view, this would be appropriate when we're talking about these sorts of platforms that are so large and so important to the way that that the information flow happens in our society, that we're regulating them to begin with. So there's that component, and then we've already spoken about the commission. So I'm going to move on to talk about parts 2 and part 3, which are the most concerning parts of the online harm bill. Part 2 includes a lot of amendments to the criminal code. There are 3 main types of the 3 main elements to these provisions. One of them is increased sentences for existing hate propaganda offenses. So for example, the existing crime of advocating side, the maximum penalty for that would, if this bill passes in its current form, be increased from 5 years to life imprisonment. And other hate propaganda offenses, such as promotion of anti-Semitism by denying, downplaying, or justifying the Holocaust, would increase from 2 to 5 years. There's also creating a new freestanding hate crime, which is incredibly broad. It has a maximum penalty of life. And the criteria for that is committing any offense under any federal act. So not just a criminal offense, but any act, any federal act, if it's motivated by hate. And part of the reason why it's so concerning that we're seeing these draconian life sentences being applied as a maximum penalty, although we've heard some language from the Justice Department and from the government that they don't expect this to actually be used in practice, where the underlying offense wouldn't call for that kind of penalty anyway, is that, one, there's a chilling effect on people's speech, where people will be more intimidated of doing anything that may potentially be seen by the state, by law enforcement, as falling within these categories, if the penalty is that much bigger. The other real concern is immigration consequences. So for people, for immigration purposes, they look to the maximum sentence to determine whether something is a serious crime. And my understanding is, immigration is not my strong suit, but what I understand from my colleagues who do look into immigration is that if the maximum sentence is over 5 years, over 10 years rather, it is considered a serious crime for immigration purposes. A permanent resident who is convicted of a serious crime, of a major crime, even if they receive a much lower sentence themselves, can still be deported and lose their permanent residency and become inadmissible to Canada. Foreign students, temporary foreign workers, if they're convicted of these kind of crimes, they're also inadmissible to Canada. So that's a very real concern for how it will affect vulnerable immigrants, especially people who might be speaking out on behalf of their stigmatized group. So I'm thinking in particular of Palestinian Canadians who may speak out in ways that are characterized by opponents as advocacy of genocide. But of course that is contested. And in this political climate where those accusations of genocide are so often weaponized to suppress speech, this is a real concern. The third thing that is very concerning, which again, my colleague here on the panel spoke to, is that they're creating a new peace bond for fear of committing one of the existing hate propaganda offenses or the new hate crime offense. so one thing that kind of mitigates this concern to some extent, but I don't think it's enough, that we shouldn't be worried about it, is that there does need to be approval from the Attorney General to proceed on this. So there's a little bit of a governor on it from the front end there, but it is based on fear that somebody might commit one of the existing speech crimes, which are the hate propaganda offenses, or commit any offense under any federal act with a hate motivation. And the penalties could include curfews, weapons restrictions, mandated sobriety with drug testing, and electronic monitoring. It's extremely draconian, and this is a very serious concern. And again, this is in the world of pre-crime. We do have existing peace bonds for things like domestic violence situations, where it's a kind of de-escalatory measure where you can still put in place protection orders to protect victims without having to necessarily proceed with charges that will lead to a conviction. And so you can kind of divert into a peace bond process. This sort of preemptive speech crime is, and peace bonds are not crimes technically, but this sort of preemptive speech restraint is novel in Canadian law and very deeply concerning. So those are the reasons why there's been an uproar over Part 2, the Criminal Code amendment. Part 3 is also controversial because it is looking to reintroduce Section 13 to the Canadian Human Rights Act. What Section 13 does is it makes it a discriminatory activity to communicate hate speech over telecommunications, including the internet. There used to be this provision in the Canadian Human Rights Act, and it was removed because of concerns that people had about it being abused and about its effects on free expression. Now they're seeking to reintroduce it in a version that is more troublesome than the original, because they're also allowing these complaints to proceed on an anonymous basis. So this is the part where you can't necessarily meet your accuser. Anonymous parties can bring forward complaints and put nothing on the line themselves, not even their good name, but potentially be awarded with up to $20,000 of in the way of a damage award from the person they're accusing. The total liability people could face not only includes those $20,000 awards potentially up to, but also up to $50,000 in fees to the tribunal. So there's a huge potential for abuse there. Now, in my reading, there isn't this sort of lopsided cost award. My reading is that they have the ability to make costs about abusive process. And my suspicion is that the government was envisioning this as being something that would help prevent abuse of the process with frivolous complaints, because people can be, even complainants could be dinged with fees, with costs, if they do so. But it's not clear from the statute that would apply, and it could certainly also apply to people who are defending. The other concern that people have about this is about the capacity of the Human Rights Tribunal, and that it could be overwhelmed by a deluge of these sort of complaints, and that other complaints that are not about speech but are about discrimination in an employment context, for example, would be delayed by this. So there are a number of reasons why people are opposed to Section 13 being reintroduced, especially in the form that allows for anonymous proceeding. Right now, at this point, most of the organized activity that I've seen has been targeting getting the government to take Parts 2 and 3 out of the bill before it goes to committee, because the committee would not be able to make such a fundamental change at that stage. It has to happen first. And so that's what we are working on organizing to do at this point, so that the other parts of the legislation that are less awful can get worked on their own without these draconian measures being in the conversation at all. The final part, part 4, is amending the mandatory reporting of internet child pornography law that already exists. And this kind of, I see it as neutral in a sense, because on the good side, it clarifies when it applies. And it also clarifies that everything that internet service providers, including like email providers, have to do under federal and provincial privacy legislation, they still have to do, even if they are mandated to report child sexual abuse material to law enforcement. On the bad side, they're also being required to provide more information than before to law enforcement when they make those requests. And just speaking from a civil libertarian perspective, I don't love any law that forces an entity to give information to law enforcement. Although in the child sexual abuse material context, that's one of the stronger cases for there being that kind of law in the book. So there's my my kind of summary of what's in the bill and what the main issues that are emerging about it are.
Okay, thank you so very much, Aislin. Now we're going to open up the floor for some questions from the online audience and give each speaker an opportunity to answer them in turn. So we will take a few questions. And our first question is this, and I will go to Aislin to answer first, and then John, if he wishes, as well. And you will have up to 4 minutes each to answer this question. And the question is this: Bill C-63 threatens arms to many segments of society, from campaigners for social justice, opponents of repressive regime that happen to be allies of the Canadian government, to landed immigrants convicted of a serious offense under the new law. Apart from addressing a parliamentary committee studying the proposed law, what should be done to oppose C-63? What do you think the CCLA and the BC Civil Liberties Association is prepared to do to rally unions, the NDP, social movements to initiate large protest actions? So I'll go to Aislin and then to John. And this question comes from Barry Wiseland.
Yeah, so I'll start. I can't speak for the CCLA. We're not affiliated organizations. So in terms of the BCCLA, we are actively working with several of our allied organizations, and also with Muslim, Canadian, and Palestinian organizations to try to support advocacy and get some coordinated efforts. So you're probably going to see some things rolling out in the coming weeks. In terms of rallying unions, the NDP, and social movements, that's not really how we see our role. We lobby, and we have spoken to NDP members of parliament about this issue. We have been lobbying, and we are prepared to continue to do that. And we stand ready to support other social movements, but we're working on really lifting up the voices, especially of the Palestinian community, and also on partnering with our partners at organizations like the International Civil Liberties Monitoring Group, or Open Media, which is an internet freedom organization, and doing some organized strategic action. So if there are particular activities going on, protest activities that could use some support, whether that's in the form of legal know your rights training to people with being more confident in what the boundaries are and what they can expect from law enforcement, or whether that's there are other groups that want to jump in on this concerted advocacy effort, we stand ready to assist, and you can certainly reach out to me directly. I will put my my email in the chat, and we can work on that. But in terms of organizing politically, we're a nonpartisan organization. We do work cooperatively with some values-aligned political parties sometimes, but it's sort of stepping outside of our role as we see it to be trying to rally these social movements and organize protests. We can do protest support, but we can't necessarily be the organizers.
Okay, thank you. John? You're muted, John. Okay, you're okay. Yep.
Okay. But I think that, for example, in the case of the of various queer organizations, that we should start alerting them to the dangers of this bill, because it's okay. Can you hear me all right? Okay. I just got a notice
Yes,
on
we
here,
can,
which
John.
Hmm?
Yes, we can hear you.
Okay, good. Yeah, I mean, we need to campaign against this where we can, and one of the areas, of course, obviously, would be the queer liberation groups of one kind or another. And I'm going to bring it up in Queer Ontario. I had heard that um, the No Policing and Pride Coalition is starting to discuss this too. So I think it's going to be a matter of people looking at this and then deciding what they think about it. So I think we should do that as much as we can. At this point, there doesn't seem to be a lot of momentum, but I guess that would depend on when the legislation comes forward, for a vote eventually. Whether that happens before an election or maybe after one, I don't know.
Okay, thank you, John. Flo?
Yeah, thank you both for those presentations. Um, I guess I'm curious to get kind of down to brass tacks, like what it makes me think is the most problematic part was the hate propaganda side. I mean, as a political activist, I guess, and um, yeah, it's just it's interesting timing, I guess, or is it, right? Like, I guess that's one of my questions too, is why do you think that the government is initiating this bill now, and versus what they're saying about why they're moving forward with this bill now, and like the real motivations behind it. And it's clear, I think, to all of us that on the one hand they're pushing through this legislation, on the other hand, in the media sphere and like culturally, we are see, and in US Congress, there's been some legislative steps as well in terms of conflating anti-Semitism and anti-Zionism. All of the marches are called hate rallies, where anybody who, since October 7th has supported Palestine is called a terrorist sympathizer. So now this language is entering bills, and that's concerning to me because I'm saying those things that people are alleging are hateful and terrorist, sympathizing. So yeah, I guess I'm curious what if this were to go forward, what like the implications really like could be, because it sounds like if it's online, then even our posts could be policed differently and have potentially life sentences. Like, that's ridiculous, but like, is that what that actually means? Yeah, so those are my two questions, and I'd also be curious to know how the lobby, the NDP, has been going, or have people been open to it, receptive, or kind of not thinking this is a big deal? I'd be curious to know how that's going. So a few questions in there, but
Okay, I hope the panelists got all these questions, and we will go to John first. You have up to 5 minutes each to answer whatever parts of the questions you want. Go ahead, John. You're muted.
Okay. Okay now?
Yes, it is.
Okay. Why the government did this now? I think it's partly because, of course, the hard right is attacking the government for not doing something about the pro-Palestinian demonstrations. And it doesn't dare because I think it knows the majority of people are pro-Palestinian to one extent or another. And, you know, that's been exposed. I mean, the whole Zionists are panicking again because their whole cover story has been blown, you know, including the lies that they tell their children in school, like, you know, a country for people with, that has no people in it already when there was 350,000 Palestinians there. But this is dangerous, and I think we have to keep. We should take this into the NDP as well. I don't. How to raise that is sort of a difficult question because most of the writing associations or electoral district groups or whatever the hell they're called now hardly ever meet. So it probably would make more, you know, get more attraction bringing it up in unions in the NDP at this point. You know, if there's a convention coming up or something like that, of course, we could really put a campaign on. But I think that's why the government's done it, and partly because, of course, they were being criticized as they always are, sometimes with you know, with some cogency, or taking forever to do anything. So I think there's that they're trying to head that off as well.
Okay, go ahead, Aislin. You have 5 minutes.
I'm not as convinced that this is a response to the particular political moment and to the atrocities that are unfolding in Gaza. I think that's certainly in the mix, but this is part of a process that has been ongoing since the predecessor to this bill was introduced and successfully pushed back against by civil society. So there's been a consultation process that's been ongoing for quite a long time, which is why I think that the actual online harm component of this is not as bad as it could be. I also think that one really important driving force that, although it's not necessarily the most concerning element or the primary thing that we draw from the bill, is a really important part of the political mix, is the protection of children from being harmed by online content. There have been a number of high profile cases where, because of online bullying or even sexual exploitation online, Canadian children have taken their own lives or otherwise self-harmed. And those are very present in these debates. I think that's part of why the more left-leaning parties did have seen this, and the also very problematic Bill S210, which is currently at committee, have seen them as, in some sense, easy wins. It's a lot easier to support legislation that gives effective, timely remedies to people who are the victims of revenge porn or the victims of online abuse. That's a lot easier and a cleaner win for a lot of politicians than are all these messy speech things. And to some extent, I think they'd rather avoid the conversation of these messy speech parts and focus on the parts that are protecting people whose intimate images are being distributed online without their consent, and protecting children who are being exposed to harm, and sometimes very grievous harm, through the irresponsibility of online platforms. Bill S210, I also think, is part of this process. That was a bill that was introduced as a private member's bill in the Senate, and we didn't really think it would get very far until it kind of unexpectedly passed second reading at the House. And since it's already gone through the Senate, it's incredibly close to becoming law, and it addresses some of these same issues, but it does so in a way that could conceivably cause the government to require people to show their ID to access websites where there might be pornography, and also require the takedown of material that is being accessed by adults or is not sexually explicit. It's a incredibly broad bill, and it presupposes that age verification technology, which often means AI and could mean facial recognition, is sufficient to allow for age verification by these platforms without any sort of breach of privacy, which is just not the case. So that piece of legislation is supported by the Conservatives, and to some extent, the government was looking to sort of supplant it with their own online harms bill. I think they've been taken aback by the pushback they're getting on the Criminal Code and the Human Rights Act amendments. And perhaps we'll be able to move them there, because even some of the groups that were initially supporting this sort of this whole package are now expressing concern. So there's where I think we have a really good chance of getting those two parts removed from this bill, so that we can focus on strengthening and improving the online harms portion.
Okay, thank you very much, Aislin. Okay, so we have 3 questions, and I'm going to go to the next one, which is Judy. Judy, go ahead.
What do you think about the government that was a government of Saskatchewan, I think it was, who tried to get the trans youth, to not to be able to necessarily exercise their rights?
Okay, so I'm going to go to you first, Aislin, and you have up to 4 minutes, and then to John.
Yeah, so this is very gravely concerning. You might be aware that there was some litigation that EGAL Canada was involved in to challenge these sort of government policies under the charter. And in response, Saskatchewan has said that they're going to invoke the notwithstanding clause, so it won't be vulnerable to charter challenge. This is a really big concern. It's unheard of so far to use the notwithstanding clause for equality rights issues, and it sets a really dangerous political precedent. The notwithstanding clause itself is included in our charter, partially because it was expected that the political cost of using it would be prohibitive. So at this point, I think we really need to be supporting people on the ground in Saskatchewan to make that political cost felt, and prevent this from being a precedent that we can use the notwithstanding clause for equality rights issues and just go about our merry way. We need to fight back, push back huge in every way that we can.
Okay, John? You got to unmute yourself.
Okay.
Okay.
Yeah, I agree with what Aislin said, and I don't think I can really add to that significantly. So I'll just leave it at that.
Okay, thank you, John. Okay, so we're going back to the question. Okay, this question comes from Tom Baker. My understanding is that the UK, US, and Australia have similar legislation, but do not include the hate speech component. Is this the case? What do you think that the government is hitching the so-called hate crimes components? John? And then I'll go to Aislin. You have
Okay,
yes, you're okay. You're okay, John.
I unmuted yet?
You're okay.
Okay. Yeah, could you repeat the question, actually? I didn't hear part
Yes.
of it.
Yes, I can. Just give me a second. Um, Give me a second. My understanding is that UK, US, and Australia have similar legislation, but do not include the hate speech component. Is that the case? Why do you think that the government is hitching the so-called hate crimes components to this bill?
Well, I think there's a good chance that the government might support something, like in terms of saying if you use certain slogans that constitutes hate, that sort of thing. I think they'd be very open to that in some ways, and certainly the hard right would and the conservatives would. So I think that's partly why they did that, because there's all this stuff in the media, which increasingly has been taken over in terms of traditional media by the hard right. The Post media, for example, and National Post and similar so-called newspapers have mounted sort of a campaign on this. It's sort of unending. It goes on every day. They denounce people for saying this and saying that and that other thing, and claim that it's a form of hate speech or it's anti-Semitic. So I think that's probably the motivation for that.
Okay, so before I go to Aislin for our answer, I'll also add that Tom added a little more intervention in this. He said, even the Fraser Institute has raised concerns about the reintroduction of Section 13, hate crime communications, because of the real world effects of the changes. Okay, has that?
Yes, thank you for that. So this is I'm not as familiar with the law internationally, so I'm not going to comment specifically on whether this is true, but certainly the criminal code amendments, they don't seem to have anything to do with the online context specifically. You can make more of an arguable case for Section 13 of the Human Rights Act because that applies to communication over the internet. But there's still, in my view, collateral issues that just gum up the whole conversation. I think what they were looking at is that there are a variety of marginalized and minority communities in Canada that are increasingly concerned with hatred and the tone of conversations online has become increasingly toxic. We've seen hate attacks against Muslims in Canada. Certainly, there's been an increase in reported anti-Semitism. Of course, there are questions we can ask about how these are characterized, what sort of biases there might be in reporting. But these are concerns that people have, and that they are reporting to the government and asking the government to do something about. So I think part of the thinking here was that this would be a really strong show of taking these concerns seriously and be something that would help get support for this whole package from those groups. Now, I think it has backfired in some ways because they are so draconian, such an overreach. And even groups that came out on day one saying we support this bill are now expressing some concerns with these particular components and how far they go. So I think it is mainly performative, and it was being done for a political reason, trying to show that they're being tough on hate. And ultimately, I don't think that the government expects that these changes in the sentencing, especially to have much real world impact at all, which perhaps is symptomatic of an incomplete analysis. And that's part of why we have this whole process when legislation is introduced, so that a more complete review and a more complete discussion can take place. but yeah, I don't think there's going to be. I don't think these provisions would move the needle on the experiences that people actually have in terms of making discussion more free and welcoming for people. And instead, I think there's going to be a huge chilling effect, even if these provisions never end up getting used.
Okay, thank you. Okay, so our next question is, it wouldn't surprise us to know that conservatives and those further to the right support C63. But which liberal groups and mainstream media outlets are backing this problematic draft legislation? Aislin and then John, 4 minutes each.
Well, in terms of who actually voted how on the first reading, you can pull information up on the parliamentary information. I don't have it in front of me, but certainly it has received support across the political spectrum. And again, I think part of that is that it is easy to frame this as the Justice Department has done in terms of protecting minorities who are at risk of being victimized, and protecting children and protecting people whose intimate images are being shared online without their consent. So again, it looks like an easy win for a lot of politicians. And this part of what we need to do is to raise awareness and make some noise and push back on these provisions, and really highlight the chilling effects that this is going to have on speech, the potential consequences for Indigenous land defenders and protesters, and generally just the way that this could contribute to making the Human Rights Tribunal even less accessible for people who need to have their complaints about employment or provision of public services heard and determined in a timely way. Yeah, so I think it's a lack of information and a lack of really sitting with the implications of it.
Okay, thank you. John?
Okay, I agree with what Aislin is saying. I think, they have various ways of trying to sell these things, and as capitalist politics these days ever gets even more cynical and performative. And most of the discussion that goes on in legislatures and in the federal house is basically empty rhetoric, which generally speaking people don't pay much attention to, which is, I guess, not surprising. But anyway, I agree with Aslan's comments on that.
Okay, well, thank you. So I see no other questions in the chat, and I see nobody's hand up. So I will go back to Aislin for any wrap up, 3 or 4 minutes that she might have left out or want to say and didn't say. It's up to her. And then I'll go to John. Go ahead, Aislin.
Great, thank you. I just want to reiterate that it is very much not too late. This bill is in the early stages of being considered. It hasn't even gone to second reading yet. And I do expect that there are going to be a variety of like letter writing tools and other campaigns that are going to be rolled out in the weeks to come in fairly short order. So I would keep an eye out for those. It's very warranted to write your MPs about your concerns. It's very warranted to speak to your friends and your colleagues and comrades about this bill and what the content and what the concerns are, and so that these the downsides of this bill, and especially of parts 2 and 3, become more well understood by the Canadian public. That really moves the needle for politicians. It really matters. And it's still very much in time that we can stop the worst elements of this bill from becoming law.
Okay, John?
Yeah, you can hear me all right?
Yes.
Yeah. Okay. Yeah, I'd like to thank Aislin for her contribution, because she brought up a number of things which I was not aware of, and probably most other people weren't too. And we really have to try and move things on this issue as much as we can. It's limited what we as an organization can do, but certainly in community organizations and in the NDP, where at least areas where it's active, where you can actually get in touch with people that are in the NDP, and in unions, and in particular, and in organizations that represent racialized communities and other community groups. We really need to raise these things because people are not really aware of it, I don't think. So far, I mean, the reporting in the mainstream media has not been particularly exhaustive, and it's not very. It isn't daily sort of. You know, it's not something that's sort of currently in discussion in the media, so to speak, except episodically. So we really should take every opportunity we can to raise these questions wherever we can.
Okay. So, folks, if you agree with what you heard during this program, please join Socialist Action, who was the host of the webinar tonight. Just sign up at our website, www.socialistaction.ca, or call 647-986-1917. It's easy to remember. 1917 was the year of the Russian Revolution. So I would like to thank very much John Wilson and Aislin Jackson. Special thanks to Aislin for joining us. And of course, thanks to Kiri, our technical producer, and to Barry and Flo, the political producers of this series of the webinars. Please consider being a supporter of Socialist Action News Report and the SA monthly magazine, The Red Review, which we will send to you online. To fill out the form, just visit our website at www.socialistaction.ca. This show has been recorded and will be posted onto the Socialist Action YouTube channel. Future SA webcasts are to be announced. Likely they will occur on upcoming Thursday evenings every 2 weeks or so. So keep in touch by joining the SA email list and by visiting the SA website. In the meantime, please be safe, stay healthy, and stay active. Bye for now.